I appreciate you bringing that to my attention. Good morning, everyone. This is the matter of Casey versus Lamont. Each side will have 30 minutes to argue. The appellant may reserve any portion of that time for rebuttal. I am assuming that counsel have read the notice concerning virtual arguments. Thank you very much. How we're going to do this is, because you can't see everyone at the same time on this particular platform, the justices will either try to get my attention by raising their hand or their virtual hand. Once you see that happen, if you'll please stop your argument so that I can address the question that's being asked by the justice, I'd greatly appreciate it. Counsel, are you ready to proceed?
Yes, Your Honor.
Yes, Your Honor.
Thank you. Counsel for the appellant, please identify yourself for the record and let me know if you wish to reserve any time for rebuttal.
Good morning, Your Honor. May it please the court, my name is Jonathan Klein from Bridgeport and the law firm of Parlatory Law Group, LLP. I would like to reserve 5 minutes for rebuttal, if I may.
Thank you, counsel. Justice McDonald will be our timekeeper.
I can't see Justice McDonald, so...
When he speaks, he'll come up, he'll flash up.
Let me see if this works. If that brings up my visual. Can you see me now, counsel?
Yes, Your Honor.
It's just your initials for me, Justice McDonald. So if you'll bring it to my attention, then I will announce the rest of the group.
Okay. Shall I begin?
Yes, counsel. Thank you.
There are three main points I'd like to address this morning. First, the governor does not have the authority under the state constitution to issue executive orders which force the closure of my client's pub. Second, CGS section 28-9, which purports to give him the authority to govern unilaterally by proclaiming a civil preparedness emergency, including suspending and modifying any laws, does not apply to the COVID-19 pandemic because the contagion of disease is not within the scope of the term serious disaster, as that term is used in the statute. And third, even if section 28-9 does apply to the COVID-19 pandemic, it violates the separation of powers provision of Article 2nd of the state constitution because the General Assembly has impermissibly, completely and irretrievably surrendered all of its legislative power to the governor under that statute. This case is about the rule of law. It's not about how serious COVID-19 is. It's about the rule of law and the inviolability of the state constitution during these trying times. My client and I fully understand how serious COVID-19 is. As I sit here today, as a matter of fact, 3 of my grandchildren, 1 of my daughters, 1 of my sons-in-law have COVID-19 and they have symptoms. 11 of my grandchildren are in quarantine right now. So I get it. But we're talking about the rule of law here. As Justice Gorsuch said about 2 weeks ago, echoing what the Sixth Circuit and what the Texas Supreme Court have said, quote, even if the Constitution has taken a holiday during this pandemic, it cannot become a sabbatical, unquote. The greatest threat to our system of constitutional government may arise when the ends are laudable and the intent is good, especially in times of emergency. Regarding the governor's authority or lack of authority under the state constitution to issue these executive orders, despite the fact that Article 4th, Section 5 vests the governor with the supreme executive power of the state, this court has held that that provision vests little or no inherent power in the governor. His primary power and duty under the Constitution in Article 4th, Section 12 is the faithful execution of the laws enacted by the General Assembly, which means carrying out those laws, putting them into effect. But by using executive orders to suspend or modify those laws at will, as the governor has done 85 times in the last 9 months, it's the antithesis of executing the General Assembly's laws. The execution of a law and changing or temporarily nullifying a law by modifying or suspending it those things are mutually exclusive.
Thank you, counsel. Justice Hecker?
Well, counsel, the Constitution does provide, as you said, that the executive shall faithfully execute the law, and 28-9 is one of those laws. And in that law, very broad powers are given to the executive. I don't contest that for a moment. extremely broad powers. But the executive is charged with executing that law. And so I'm wondering, first of all, how your argument deals with the fact that that's a law. 28.9 is, and also that 28.9 does seem to place quite specific limitations on the executive's exercise, because it says, at least in sub 1, and we could go through them all, but sub 1 seems to be at play, that the modification of any existing law has to be as reasonably necessary to protect the public health. And so my question is, doesn't that provide, that gets to your non-delegation point, and it's a long question, so you can answer any part of it, sir. But if you could respond, I'd appreciate that.
Yes, Your Honor. Well, although 28-9, of course, is a law, the governor can only exercise, I think it's CJS Section 3-1 authorizes him to take proper action to protect the citizens of the state. But enforcing an unconstitutional law is not proper action. It's inherently improper action. So it doesn't get us there. As far as well, that's a circular argument, though. I mean, he's charged with executing the law. Why doesn't this law? Why is it unconstitutional? Why doesn't the reasonably necessary to protect language provide sufficient guidance for him? And a subsidiary question would be: you don't claim in this case, do you, that the executive orders that are challenged are not reasonably necessary to protect public health? As I understand it, that's not one of your claims. That's not one of our specific claims, but what that statute does, it doesn't set any rules, any guidelines, any bounds for the governor. Whatever he thinks is right is what goes. So he can rule by fiat. He essentially becomes it has to be reasonably necessary to protect health. But no, if it's not, then it could be challenged. But it can't be challenged. One of the things is that one of the failings of this statute is that it doesn't allow the legislature to override the governor, to even challenge the governor. What the governor can do whatever he wants, whatever he thinks is best. And I mean, the governor is essentially playing God under this statute. And
counsel, hang on. Couldn't the legislature stop the governor if they thought it was unreasonable?
No, Your Honor.
Why not?
Because the way the statute is written, the only time that they have any power to do that is if he's doing something with respect to a man-made disaster. Other than that, what could happen is the legislature could try to enact a law that does something contrary to one of the governor's executive orders, and the governor can then veto that law. The legislature can then try to override that, and the governor can just suspend the law that gets passed over his veto.
And then it would be before us.
What we're talking here about the tension between the governor and the legislature.
Well, I understand that, but if it's not reasonable and the legislature passes subsequent legislation and the governor, quote unquote, vetoes that, then they can come before us, couldn't they? Somebody has to bring a lawsuit. True. Somebody would have to bring a lawsuit. It doesn't happen. They can bring a lawsuit. They can bring it, couldn't they? Or one of the members. I'm sorry, Justice Acker. I cut your questioning off. I apologize.
No, not at all. I'm done. Thank you very much.
Justice Khan.
Thank you. Thank you, Chief. So I have two questions around the issue of your argument around the separation of powers and what, as a follow-up to what Justice Ecker just asked you. In addition to the limitation that Justice Ecker asked you about, the reasonably necessary, there is also, of course, the sunset provision. That the powers are invoked when there is an emergency preparedness or a declaration of a serious disaster. And that lasts only 6 months, and the legislature retained by special committee the power to, within 72 hours, challenge that designation. And as I understand it, the governor issued the first declaration in March to last through September, and then reissued it in September through February. And the legislature didn't seem to have invoked that authority. So there is that additional restriction. So my first question is, why isn't that enough? In other words, the legislature could have in September challenged the governor's continued use of that authority in September. And after that question, my next question or second question is, if your claim is that 28.9 is unconstitutional as drafted, what language, in your view, would the legislature have had to have used to render that provision constitutional?
Okay. First one, what the what the governor did when he extended the his first 6 months into February, I believe he did that under CJS section 19A-131A-B1, which the state has at the trial level abandoned as a basis for the executive orders. That provides a mechanism where there's a 10-member committee of the General Assembly which can disapprove a declaration of a public health emergency. But under 28-9, it's not a declaration of a public health emergency. It's a proclamation of a civil preparedness emergency, and they're slightly different. 28-9 doesn't give the legislature the opportunity to do that within a 72-hour window. They can't do anything to head off the governor's proclamation of a civil preparedness emergency. Once that train leaves the station, it's gone. The legislature can't pull it back, and they can't stop it. So the as far as the second part of your question, Your Honor, what was the second part of your question again? I'm not hearing you.
Justice Khan, you're muted.
Okay.
Can you hear me now?
Oh, I can. Your second question, sorry, Your Honor, was what?
Thank you. So the second question is, what could the legislature, how would the legislature have drafted 28-9 in your view to render it constitutional? What would the language have been that would have amounted to a proper delegation of authority that would render it constitutional?
They can follow models that were followed in a number of other states. There's let's see, Pennsylvania, Michigan, Oregon, Kentucky, Massachusetts are examples of states that have crafted emergency powers, which, first of all, they encompass the contagion of disease, unlike Connecticut's statute. And I talk in my brief about how Pennsylvania, Michigan, and Oregon dealt with that, and the Michigan and Michigan Supreme Courts dealt with that. But in the Kentucky and Massachusetts cases, which the Massachusetts case was decided just yesterday, I think really shows this very clearly. What happened in that case, where the Supreme Judicial Court held the Civil Defense Act covers COVID-19 and does not violate separation of powers, they found that there's no separation of powers because the way that statute is crafted, the legislature retains the power to enact legislation addressing the pandemic.
So in response to my question, what you're saying is, if the legislature had used contagion of disease in its definition of serious disaster, then that would be okay in your view, then it would be constitutional. Is that your argument? Because that gets back to your first issue, which then would prompt my question of the language, statutory language, including but not limited to, in its definition of natural disaster. Why couldn't that include any catastrophe, including but not limited to? Why couldn't that include something like the COVID pandemic. So are you saying that the constitutionality depends on the definition?
No, what I'm saying is even if the definition deals with the question of whether 28-9 covers this pandemic, but I'm also arguing that even if it does, the way it's written, it's unconstitutional. If I can talk about the Massachusetts case, it'll point that up. They found that the legislature again retained the power to enact legislation addressing the pandemic, which it has done many times during the pandemic. That's not the case here. The legislature retains the power in Massachusetts to make any part of the CDA inoperative by a joint resolution. That kind of power doesn't exist under our statute. In Massachusetts, the legislature retains the power to curb the governor's powers under the CDA if it desires to do so. We don't have that here. The CDA does not interfere with the function of the legislature. That's not the case here. And finally, the CDA went at great length, 21 pages of substantial detail and guidance in the statute, setting forth a very specific policy and a framework within which the governor can work. But that's completely absent from the statute in Connecticut. So if Connecticut had legislated similarly to the way the Massachusetts legislature did, maybe it would get over the constitutional barrier. But the way our statute is worded, it's a far cry from what Massachusetts did.
I thank you for responding to my questions. I yield back to the chief so my colleagues can ask their questions as well. Thank you.
Thank you. Justice Daria, then Justice Keller, then Justice McDonald. Thank you.
This may be a quick one. If you have, you're looking for an injunction, and which is strong medicine against the chief executive officer of the state, and you've alleged no adequate remedy at law. So do I understand that to mean that you don't think there'd be a taking claim here of any sort, condemnation or some sort of regulatory taking? If you haven't thought of it, then that's my answer. But I'm just looking to see if you didn't think you had a claim.
I don't know. I don't know that there's a taking claim exactly. What I do know is that you can't sue the governor for money damages. So, and
well, I mean, no, I mean, that's not true. If it's a taking, that would be an exception to sovereign immunity. And I guess you could also go to the claims commissioner. But if that's not something, in alleging no adequate remedy at law, that would be something we would have to consider, I think, before entering a judgment.
But at trial, the state did not contest that aspect of our complaint. They didn't contest that there's irreparable harm or an inadequate remedy at law, which is why the trial only dealt with the issues of law.
Thank you.
Justice Keller.
Thank you, Chief Justice. Good morning, Attorney Klein. I want to dwell a little bit on your argument that the COVID's not a serious disaster not being defined. Linguistically, the trial court found that there's really very little difference between the definition of serious and major. And I, quite frankly, think that linguistically, major is more serious than serious when you say major catastrophe. The definition of major says that there's a major catastrophe, including but not limited to certain things, whenever the president declares under the federal law that we have a major disaster, and whenever the governor declares a civil preparedness emergency. So what doesn't that eliminate this claim of yours that we don't have a serious disaster here?
No, Your Honor. Colloquially, serious disaster means bad stuff, but we have to be more precise than that. And other state legislatures have been far more precise than Connecticut legislature has in defining what kind of conditions trigger these extraordinary powers of a governor.
Wouldn't it be a bizarre result if we were to conclude that COVID-19 is not serious, but certain other things in this statute that are actually delineated as serious are far less catastrophic? A snowstorm.
No, Your Honor, here's why. Back in 1975, when the legislature made some amendments to the definition of disaster, they specifically had in there a reference to natural causes that cause an epidemic. That would have been fine for COVID, but then just 4 years later, they intentionally excised that from the statute. So I think that very clearly shows that when they came up in 1979 with this current definition of major disaster, they intentionally removed epidemic or pandemic, it's the same thing, from the scope of that statute.
Well, weren't they really just trying to model something after the federal law? And they left in the including but not limited to. And isn't that expansive? And aren't we to interpret it that expansively?
No, because they also took out the phrase other catastrophe and then put in something about man-made disasters. So it's just, they intentionally removed it and they never looked back.
All right, thank you.
Justice McDonald.
Thank you. Counsel, to follow up on that, I mean, it does say including but not limited to, so there's maybe some light in there, but it just seems to me that we have had, yesterday alone, more Americans died of COVID than died in 9/11. And to date, more Americans have died than died in battle in World War II over 4 years in 9 months. It's kind of hard to get your head wrapped around that not being a serious disaster. But I'm wondering whether we have to go there. And this is probably a procedural question more than anything else. In your complaint, you challenge the governor's issuance of his executive order under the public health emergency. And I understand that you say that they abandoned it, but it wasn't theirs. I mean, it was your allegation. Did you prove in that allegation that there was not a public health emergency?
All I alleged in the complaint, Your Honor, was that the governor purported to act under both that public health emergency statute and 28-9, the civil preparedness emergency statute. I didn't agree with that. I didn't agree that he had the authority to do that, but the trial court said that, and it was that the state abandoned that.
Well, it said something a little different. It said that the state didn't brief anything about it. Did you brief it and they failed to respond to your briefing? And how exactly did they abandon it? Has the governor ever withdrawn the public health emergency declaration?
The governor hasn't withdrawn it. To answer the first question, I believe, I don't have it in front of me right now, I believe I did brief it.
Okay, and the state never responded to that?
Attorney Miller can respond to that. I don't believe they did.
Thank you.
Were there other questions?
Continue, counsel.
Okay.
No, you may continue.
All right. Another thing about 28-9 is it does not set out any what's called intelligible principle, or any principle for that matter, to guide the governor in exercising his authority. It doesn't set any guidelines for him. Again, other states have done a good job of doing that. It hasn't been done here. The General Assembly just said, okay, Governor, we got to, in this situation, you do it, leave us out of it. They just punt, they walk off the field, And they say if you need to, basically, it's like it's saying if you need to break the separation of powers, go ahead. We're not doing this. It's all up to you. And they can't do that. They can't forfeit their right or delegate their right under the Constitution to legislate, and the governor can't usurp that right.
Counsel, once again, it seems like you're writing out the word reasonable. The governor can do what's reasonable. So how are they abandoning their duties if they do have that break where they can come back and pass through subsequent legislation or litigation? They can put a check on the governor's powers. It seems to me that it's there, and I don't understand your argument to say it isn't.
The only way they can put a check on his powers is not legislatively. It's by
Why not? Why not?
As I said before, they could try. They could pass a law, but the governor can override it.
What if the governor doesn't veto it? What if the governor acquiesces to it? Or if he does veto it, you have the court system. But it seems to me that is a machine that's in place. You may feel that it's not the best of machinery, but it's a machine that's in place to deal with this.
But it's not legislative machinery. If the legislature or someone else they find sues in court to deal with the situation, suing is not the legislative function of the
No, I'm going back to passing legislation which says that, Governor, you exceeded your powers.
There's no teeth to that because the governor can just disagree with it and he can veto it. They can override his veto and then he can suspend that.
That's true in any piece of legislation. The governor can ignore it at his own risk.
He can't. The governor doesn't normally have the power to suspend or modify law.
He doesn't have the power if it's not reasonable.
But reasonable is just up. It's at his whim.
It's at the legislature's control. They get to decide whether he did something that was reasonable or not. And you seem to just ignore that. And I'm trying to figure out how.
There's just no check on what the governor feels is reasonable.
There is a check, the legislature. And if the governor defies that, then they have the court system. And that's how it is with every other statute too. I don't understand your argument.
The court system is not, using the court system is not the legislative function of the legislature.
But it's
outside.
You're ignoring the first part of what I said. They can pass legislation and the governor has to adhere to that legislation. If he doesn't, there's a mechanism to deal with that. But you're just cutting out the first part entirely, saying you can ignore it.
They can pass legislation, but there's no teeth to it. There's no teeth to it because
there's no more bite than any other piece of legislation. I understand that, but I don't understand how it is a totally toothless tiger.
I mean, if the governor would just ignore or override, modify or suspend a law under normal circumstances, not emergency situation, it might even be an impeachable offense. This gives the governor.
This may be too. If they act and they say that what you did was not reasonable, you exceeded your powers, and you're still ignoring us, that may be an impeachable offense, correct?
Maybe, but again, I'm just repeating myself. That's not the legislative. That's not an exercise of their legislative function. If they want to, that's fine, but it's not.
I understand your position, but you seem to be ignoring the first part of my question.
I'm
not ignoring. You're not answering to my satisfaction. I'm sorry, counsel. I didn't mean to say it that way. I did not see the order of the judges, so I'm going to call an order of seniority. Justice McDonald.
Thank you, Chief. Just quickly, I don't know if it's in the record, but I seem to recall that the statutory committee of legislative leaders did in fact meet, and I think they voted to affirm that the governor's declaration should stand. Is that incorrect?
That was acting under 19A-131, not under 28-9.
Oh, I'm not certain. Does it make a difference?
Well, it got dragged along with it, but that mechanism doesn't exist in 28-9.
Well, that gets back to my original question. The governor has never withdrawn the public health emergency, and the legislature has acquiesced in that declaration, and the same executive orders are permitted under 28-9 in a public health emergency. So what's wrong with that reasoning?
I didn't follow the question, Your Honor. I'm sorry.
So the governor issued a public health emergency in addition to a civil preparedness emergency. The same executive orders that he issued were allowed under 28-9 in a public health emergency as well as a civil preparedness emergency. The legislative leadership has acquiesced in the, according to you, in the public health emergency declaration. And so why are those orders not entered with legislative acquiescence?
I guess they were under 19A-131A. There was that modicum of legislative acquiescence. But again, in this particular case, the state is not relying on that as support for the executive orders.
Okay, I'll ask the opposing counsel. I mean, just because it didn't brief it doesn't mean the declaration has been withdrawn. Does it? Let me end with that. Does it?
No, declaration has not been withdrawn.
Thank you.
I believe my time is up.
Counsel, before you step down, Justice Ecker has a question, and also Justice Keller.
Counsel, just going back to your colloquy with the Chief Justice and a few of my earlier questions, if this statute, instead of telling the executive that it could do what it did, said that in the event of a contagion, or, and I putting aside, in event of a public health emergency, or in event of a plague or contagion or pandemic, the Department of Health has authority to issue regulations, any regulations it deems reasonably necessary to protect the public health. Would your claim be that that would be an unconstitutional delegation of legislative authority to the Department of Health?
No, that would probably be all right, because the legislature does have the authority to set a policy and a framework, and then have the administrative agencies fill in the blanks with.
Well, isn't that what it did here? The policy here under subsection 1 is you can do what you need to do to reasonably necessary to protect the public health. How's it any different from telling the administrative agency that it has that authority?
Because the governor is not an administrative agency. He's the head of the state, and he
runs the administrative agency, sir. I mean, that's the executive branch.
The administrative agencies are part of the executive branch, but when the legislature does that, and there are dozens of instances in which the legislature has done that, they formally set forth, here's what our policy is, and then they go ahead and they allow the administrative agency to promulgate regulations to fill in the blanks. They haven't enunciated a policy here.
Okay, thank you. I'm done, Chief.
Thank you, Justice Ecker. Justice Keller.
Your Honor,
you're muted. You're muted, Justice Keller.
I'm looking at 19A-131A, which is the authority to declare the public health emergency. Do you believe that that statute only authorizes the governor to do certain things, and in that statute, what it authorizes the governor to do, which is basically to get the public health emergency response plan in effect, did that not include what occurred here, which was the limitations on bars?
No, I don't believe it did.
So what would you assert that the governor, in order to close the bars, had to do it under 28-9 and could not do it under 19A-131A?
Let me have a moment. Let me look at the language.
It says, order the commissioner to implement the public health emergency response plan. Now, I don't know if that encompassed closing restaurants and bars. Order the commissioner to isolate or quarantine persons, vaccinate persons, and suspend license renewal and inspection functions. Isn't that somewhat limited under that statute?
Well, what that's talking about is implementing regulations which already exist,
Okay.
not creating new executive orders that are making it up as we go along.
And you would say that there's no authority to close bars under that statute, 19A, the public health emergency?
Not unless there's some existing regulation that says so, and not that
Okay.
I'm aware of.
All right, thank you.
Justice McDonald?
I'm sorry to extend this, Chief, but counsel, in response to Justice Keller's inquiry, General Statute 28-9B1 specifically says that after the declaration of a civil preparedness emergency or a public health emergency pursuant to 19A-131, the governor can modify any statute or regulation or requirement or any part thereof, right?
Let's say that, yes, Your Honor.
Okay, so is that a clarification of your answer to Justice Keller that executive orders can modify statutes and regulations in the context of a public health emergency?
I have a moment to look at the language of this. I see what you're saying, Your Honor, but I stand by my answer to Justice Keller.
Well, what am I reading wrong in that statute? That specifically the part that says, or a declaration of a public health emergency pursuant to section 19A-131, the governor may modify or suspend in whole or in part by order as herein provided any statute, regulation, or requirement or part thereof. What's not plain about that?
Well, as it goes on to say that if the governor finds any such statute, regulation, or requirement or part thereof is in conflict with the efficient and expeditious execution of civil preparedness functions or protection of public health. So it talks about the civil preparedness. That's I think it's still a problem, Your Honor. And again, since the governor is apparently no longer relying on 19A-131 to justify his executive orders, seems to have waived that issue.
Thank you.
Thank you, Mr. Klein. Once again, I want to apologize for saying that you were ignoring my questions. You weren't. You were respectfully and zealously representing your client. I just want to make sure you understand that.
I understand that, Your Honor.
Mr. Miller.
Thank you. Good morning, Your Honors, and may it please the court, Assistant Attorney General Philip Miller, and I am representing Governor Ned Lamont. Your Honors, this is a serious disaster, no matter how we try to define that term. I mean, as it's been pointed out, over 5,000 Connecticut residents have already perished. If you look at projections, it looks like there will be hundreds, if not thousands more before this pandemic's over. 140,000 residents have already contracted the disease. It has impacted all our lives. I mean, we can't even be together today to have this argument. So COVID-19 is a serious disaster. So I think the important issue in this case, I think what the court was discussing earlier, is can the legislature constitutionally delegate to the governor, at least in this case, a portion of its police powers, so that here, March 16th, 2020, Your Honors, the legislature has closed the Capitol complex. One of the legislatures has contracted COVID-19. Can the legislature delegate to the governor its police powers so that the governor can take the actions it took in this case, which initially was to limit bars and restaurants, to take out food and delivery, and then subsequently try to loosen those restrictions in a thoughtful, deliberate manner as best they could, given the science and the ability to limit transmissions, and all do this to protect the public health? And Your Honors, the answer to that question is yes. I'd just like to quote Justice Jackson briefly. He said, "There is a danger that if the court does not temper its doctrinaire logic with a little practical wisdom, it will convert the Constitutional Bill of Rights into a suicide pact." and I'm not trying to be too dramatic here, but I think what the plaintiff seems to be suggesting is on March 16th, as you know, we know what COVID's done. It swept through Europe. It's in America. People have died in the state of Washington. The governor had to sit back and just really hope the legislature could figure out how to get back and pass laws. And that is not what our Constitution requires, Your Honor. I'm sorry. I see there's a question already.
Thank you, Counsel. Justice Keller? And sorry, I didn't get the order. Let me do an order of seniority. Justice Kahn and then Justice Keller.
Thank you, Chief Justice Robinson. My question is, it's twofold and related. Do you agree with your opponent's response to Justice Keller's questions and Justice McDonald's questions that you did not argue the power that the governor has under 19A 131A B1, and particularly the power that the committee has to convene and challenge the declaration within 72 hours. Did you abandon that claim?
No, Your Honor. So what happened was, I did not, Your Honor, but here's what happened. When the plaintiff filed his complaint, it has challenged numerous executive orders. And some of those executive orders, we believe, did not solely use the governor's B1 powers, which loops back to 19A 131A, but also invoked the governor's B7 powers. And the B7 powers, Your Honor, we believe you could not invoke some of the things he did under B7 solely by declaring a public health emergency. So we fully briefed and argued is this a serious disaster issue, because we felt it was necessary in order to encompass the scope of all the governor's executive orders. And so I think probably maybe it was my mistake, Your Honor, when we briefed it, we focused solely really on the 28-9 arguments, because that's what we felt we needed to get through to have all the executive orders protected. But we never, I think I dropped in a footnote in my reply brief because it also hadn't come up, because in his initial briefing, in his initial complaint, it really was unclear he was challenging any suspension or modification of rules. That only became clear during the briefing. So in our reply brief, I did drop a footnote saying that 19A 131 has been enacted, but we didn't feel it would cover all the executive orders, which is why we fully briefed the civil preparedness emergency statute, Your Honor.
And so, thank you. And my follow-up question to that is, with regard to 28-9B7, in your opponent's claim that basically the legislature was just handing over the keys and not, giving complete control. I think he used letting the governor act as God. In response to that argument, beyond the language of the statute itself, which the limitations of that the acts of the governor have to be reasonable, are there other external constraints in the statute? In addition to, would you agree that the right of the legislature to basically reassess the declaration within 72 hours and to reassess the continued declaration being an external constraint that the legislature retained? Are there any other external restraints that the legislature created beyond what's in the statute that constrains the actions of the governor himself in terms of the reasonableness? Did you follow my question?
Yes, I believe so, Your Honor. First, I do want to point out that under 28-9A, Your Honor, the legislature can only come in and challenge the disaster if it's resulting from a man-made cause. So, but however, under 19A 131A, the legislature does have the ability to come in and challenge the public health emergency. And it did in this case twice. And there was a vote in early September. I think they call it the Group of 10. And they reaffirmed the governor's declaration of the public health emergency. So, Your Honor, I do think we can draw something from that. Going, I think, to Justice Robinson's sort of issues is that clearly demonstrates that the legislature fully was on board with the actions the governor takes. Now, that alone doesn't make them constitutional, I understand, but it certainly shows that they at least were in acquiescence. So I think that is somewhat of a check, Your Honor. Yes, because I think, as Justice Robinson pointed out, it would be an interesting, question that we could have if the legislature declined the public health emergency. that would be a different case, which we don't have today, that there might be implications from that we would certainly have to litigate. I think now more to the rest of your question, Your Honor, there are other limitations. So first of all, there's more limitations, I think, just in the statute. So first thing the governor has to do is he has to declare a civil preparedness emergency over a severe disaster. It can't be just over anything. And that would be a point of litigation possibly, in the future. Now, in this case, I think Attorney Klein, to his credit, admitted that this is clearly serious. Now, he would say it doesn't fit into the definition precisely, but he does not dispute, and I'm very sorry to hear about his relatives with COVID-19. He doesn't dispute how grave this is. So there's that check. And in addition, Your Honor, all the steps he has to take, any action he takes, has to be tied to this pandemic, this catastrophe. So if COVID-19 were transmitted only by touch, well, that would be a different scenario. Maybe some of these rules wouldn't be necessary. Unfortunately, the transmission path of COVID, it seems necessary to take broader action. Now, if this were a hurricane or a mudslide, there'd be much more narrow things that the governor could do in that sense to protect the public health. And lastly, I'm sorry I'm going on, Your Honor, but I think one more point I want to bring out, this again goes to, I think, Justice Robinson, is currently right now, there are suits in state and federal court challenging the governor's authority to do certain executive orders. Is it a First Amendment violation? Is there a freedom of speech? Is there a freedom of assembly? Is there a due process? Is there an equal protection? Those challenges are ongoing right now as we speak. So that is another avenue. And I think the Massachusetts court noted this, and some of the other courts, that have upheld similar statutes, the Kentucky Supreme Court, the Pennsylvania Supreme Court, they've noted the ability of people to go into court to bring these types of actions. I hope I've answered your question, Your Honor.
You've answered my questions. Thank you. I return it to Chief Justice Robinson. Thank you.
Justice Keller.
Thank you, Chief Justice Robinson. So getting back to the distinction between the public health emergency and the civil preparedness emergency, these particular executive orders, were they not allowable under a public health emergency declaration?
So, Your Honor, initially, the very first order that was issued by the governor in respect to this case was Executive Order 7D. And what 7D simply did is it said all bars and restaurants, you may only serve takeout, food, and non-alcoholic drink. At the time we issued the executive order, Your Honor, we did not view that as an amendment to a statute, to be perfectly frank with the court. We saw this as sort of like, you have a driver's license, we have licensing statutes, but the roads are horrible, there's a terrible blizzard, no one can drive. We weren't amending statutes. Now, I think as time has gone on, and clearly when Executive Order 7, I believe ZZ, established the sector rules, now we've amended statutes. So I think what became initially we thought was a very temporary measure has certainly become amendments of statutes, including the cafe statutes and things like that, to be able to serve food and drink.
All right, but is that part of, is closing restaurants or restricting restaurants as to how they can serve food and drink, is that at all part of the public health emergency response plan developed by the Public Health Commission?
No, it was not, Your Honor.
Okay.
So that initial action, at least initially, we felt we were exercising our 28.9 subsection 7, B7 authority, Your Honor.
Now, I have just one more question. Your opponent seems to indicate that the 28.9 only allows the governor to issue executive orders in the event of certain enemy attack, sabotage under subsection B8. But doesn't one allows the governor to specify, and he's required to specify in such orders. Should we distinguish between the use of the word order and the use of the word executive order in this statute, or are they one and the same?
Your Honor, I think they're one and the same. I mean, I think we have to, again, step back and say the governor, this under 28.9, assuming it's constitutional, the governor is allowed to take, look at B7, any action that he deems reasonably necessary to protect the public safety, health, and welfare. He has to have an ability to get that information out, and I think certainly the executive order is a form. I think the B8, that maybe is the only thing he can do under B8 is issue executive orders. Under B7, he could do much more. And in B1, I think it specifically says order, and I think, yes, that would be executive orders, Your Honor.
All right, thank you.
Justice Doria.
Thank you, Attorney Miller. Is there or should there be a durational limit to aspect to the separation of powers question? My point being, this is not a snowstorm. Snowstorm we clean up after a few days. This has gone on for many months now. The legislature is poised to come back into session. Maybe we'll see. I think your opponent's point would be, okay, at some point, I think you suggested, we've modified, we've amended statutes, is there a reasonableness point to be made about separation of powers where nobody expected the pandemic to go on this long, but, we're coming to work and the legislature should come to work and the whole body should take action or decide not to?
No, Your Honor, I don't think there needs to be a temporal limit given all the other checks that are on, the governor's actions that, I think Justice Robinson and others have alluded to. Again, I think it's because it has to relate to the scope of the pandemic. And again, you said, the legislature might come into session. They might. And now as we get into, it looks like the second wave, will they be able to? Imagine if the pandemic were the Black Plague that was wiping out.
Let's say they did. Let's say is your position going to be the same if the session comes and goes? They've been in session. They're passing other laws. They don't do anything about this. I guess you could say that's acquiescence. I think the plaintiff's client would say, I want my elected representative to have something to say about this.
That might be what they say, and I think I think the Michigan dissent pointed out that if they're not happy with the legislative response, then they can vote out the legislature. As long as the statute, I think, goes back to the delegation question. If the statute declares a legislative policy and provides an intelligible principle by which for the governor to act, then that is a constitutional statute. I understand it's broader, especially in this scenario, but it's a constitutional statute. And just like other statutes need not have a time frame, a limit, a sunset provision, I don't think this one necessarily has to either, Your Honor.
Well, okay, so I just one other question do you have a position, or does the state, would you concede that this could be a condemnation of her business at some point?
Your Honor, I don't think so. And given the taking law, my understanding of the taking law is if it is for the public use, well, I should say, there's certainly U.S. Supreme Court case law that is discussed when property is taken for purely the public good, then no compensation is required. I can't remember the names of those cases off the top of my head, but for example, there was a case involved, I believe, property that was being infested. And they cut down, the U.S. Army Corps of Engineers cut down every single tree on that piece of property. And the Supreme Court held there's no compensation due for that simply because that was for the pure public good. It had to be done. No one has a right to property if it's going to harm the members of the public. I think, again, there would be an argument, Your Honor, there would be no compensation under this situation, but that was something that would have to be litigated.
Okay, thanks.
Justice Ecker?
Thank you, counsel. I just want to, look, we're dealing with a situation here where there's no claim that the governor is acting in bad faith, is trying to accumulate power that, he's not entitled to, is staging a coup d'etat, or anything of that nature. My concern is, I think the other side's concern is, under this statute, because it contains no role for the legislature, at least in the event of a natural disaster, you could imagine a really problematic situation where there's a disaster that's declared and then the governor just doesn't end it. And during that time, he pretty much has control to do anything he wants. It has to be reasonably necessary. It has to fit within those, but it's very, very broad, I guess, is what I'm saying. And if, for example, there wasn't a majority in the legislature, if the party had control of the governor, there couldn't be a legislative override. And my question is, does that aspect of, it's two parts. First, does that aspect of this statute make it different from what other states have deemed to be constitutional like Massachusetts? And secondly, should that be of a concern to us? It's of a concern, obviously, to the plaintiff here.
So, yes, Your Honor. So first, as to the other states, in Pennsylvania, there is a provision that the houses could issue a joint resolution disapproving the, well, I can't remember what their emergency. However, that was litigated to the Pennsylvania Supreme Court, and the Pennsylvania Supreme Court said, well, that still has to be presented to the governor, and the governor could veto it, and then you'd still have to override that. Massachusetts said the same thing yesterday. I think they might say concurrent resolution, but I don't know the answer to the question if that would also have to be presented to the governor and, you know, have to override that veto. I believe Kentucky, I'm sorry, you were going to say something? Okay. I believe Kentucky, they did have a provision that the legislature has to renew it every 30 days. Your Honor, certainly I'm not saying, we're not trying to make light of this. I mean, this is an extraordinary situation. And I think the breadth of the powers are sort of because of the breadth of this situation. But what I would say is there are sufficient checks on the governor. First, the legislature certainly has the ability to attempt their checks. And as Justice Robinson points out, if they seem to be trying, saying this is not right, this is not a serious disaster anymore, this is not a serious disaster, well, then there's the avenue of the courts. Because remember, the governor can only act when there's a serious disaster. And even I'm sure a day comes that COVID-19 is no longer a serious disaster. And then if the governor continues to attempt to extend powers after that, then that's certainly something that the courts will be able to be involved in. So there are checks, Your Honor, on this.
Thank you.
Justice McDonald.
Thanks, Chief. Counsel, just a couple of things. First, President Trump declared a Stafford disaster, didn't he?
Yes, Your Honor.
How does that play into our consideration of whether this is a serious disaster or a major disaster?
Yes, Your Honor. So
was a disaster declaration or a civil preparedness emergency by the governor even necessary after the president declared a Stafford disaster?
Well, certainly, Your Honor, a declaration was necessary because the president declares it a major disaster, the governor would still need to follow through, I think, and declare a civil preparedness emergency in order to effectuate the powers under 28(9). Now, but I do think, to your point, Your Honor, when the president of the United States declared it a major disaster, that gave him the ability to clearly make this a serious disaster. And to your knowledge, I just have to confess I don't know enough about the Stafford Act. Are those declarations limited to the types of natural disasters of hurricanes and that type of thing, or does it also apply to public health emergencies? So under federal law, Your Honor, the term major disaster is almost identical to what our statute was in 1979. It was basically any natural disaster, including but not limited to, and it gave a bunch of titles. The federal government has concluded that this is a natural disaster. Now, our definition of major disaster is broader than the federal definition, and it also says including but not limited to. So it's broader than that. But, Your Honor, I don't think the court needs to even get to that issue because I think this is clearly a serious disaster. When the legislature enacts statutes and they have two slightly different terms, serious disaster and major disaster, the court usually assumes that there was a reason for those slightly different terms, or they mean something slightly different. And I think in this case, what it means is the way the definition of major disaster has now been modified, including in 2006, any major disaster is necessarily any major disaster is necessarily a serious disaster. But it's maybe possible that not all serious disasters would not fit a major disaster.
That goes back to Justice Keller's point, but let me ask you this. Your opposing counsel points out the fact that definitional language was adopted about 30 years after the Spanish flu. And so they clearly understood, or I would assume that they understood the scope of a pandemic. But but all of the, I know, I understand it says not limited to, but all of the itemized issues are natural disasters, not health-related disasters. What do we make of that, and how do you respond to that?
So I think 2 points, Your Honor. So first of all, it was, and Councilman must have missed it. It was not 30 years. The Civil Preparedness Statute, I began in 1950-ish. I think it was 51 or 52. But this whole language about what is a disaster was not put in effect till 1975. So I'm going to be a little long with this answer, Your Honor, but I want to make sure I fully explain. So in 1975, so before 1975, civil preparedness emergencies only applied to serious natural disasters. In 1975, the legislature decided, and there's legislative history on this, boy, we need to include more things, including man-made disasters. So they amended 28.9, the definition of serious disaster, a public health emergency, say it shall be, instead of a serious natural disaster, a serious disaster, thus broadening the scope. And then they put a definition of the term disaster, and that included epidemics. So it shows you the legislature was contemplating man-made disasters, epidemics, oil spills, all these terms that they talked about in the legislative history. Now in 1979, because of the Stafford Act, the General Assembly again amended the statute. And the legislative history speaks about that they did it because they wanted to ensure federal and state were aligned so we could get aid from the federal government. They removed the definition of disaster entirely because that's not in federal law, and they put the definition of major disaster in. And major disaster at that time, was narrower. It didn't include oil spills or man-made disasters or epidemics or anything like that, so those aren't in the definitions. But there's absolutely nothing to suggest, even in 1979, did the legislature intend the scope of the civil preparedness emergency not to include those terms, especially when they put them in 4 years before. They just simply wanted to align state and federal law.
And my final question, and I'm not asking you to go through them all, but if we look at the executive orders that are applicable to this case, will it be clear whether the governor is invoking his B1 powers or his B7 powers in each particular executive order?
John, I think the only confusion might be, as I said initially, when the governor issued Order 7D, he would not believe that he was modifying any statute. It was simply a temporary pause in the way businesses operated.
Fair enough, but all of the additional ones, are they under B1 or B7, or does it specifically say state?
Well, I believe, for example, 7ZC says, I am modifying the following statute. So I believe they've attempted in all their executive orders where they were modifying a statute, at least intentionally, to indicate in the executive order as required what statute's being modified. So that would clearly be under the B1 power. Now, for example, I'll give you Executive Order 7N that they look at. That was under the B7 power because it's terms about like touchless payment method and how to ingress and egress from restaurants. There was no statutes on that, so that was done under the B7 power.
Okay, thank you.
Justice Mullins.
Thank you, Chief. Just a couple of quick questions. I wanted to ask you, if you could, to respond to the Michigan case. There was a piece of the Michigan case that also used the language reasonable and necessary, and as I remember it, that wasn't detailed or specific enough. I know there were other pieces of the case, but would you comment on that piece? And sort of relatedly, I was going to ask you about the intelligible principle at issue here. But first, would you respond to why the majority got it wrong, I guess, in that case, that reasonable and necessary in our statute is detailed and specific enough? Yes, Your Honor. First, I'll be frank with you. I believe that the Michigan case was wrongly decided. I think the dissent in the Michigan case had it right. I think the majority decision, I believe, attempts to read the words reasonably necessary just alone without the full context of the statute that I think a number of the questions in this court today have pulled in. I don't think the standard, for example, in our case is just reasonably necessary. The governor can't do whatever is just reasonably necessary. First, it has to be tied to the health, safety, and welfare of the citizens of the state. It also has to be directly related to the actual, in this case, the pandemic. So, again, Your Honor, just a quick example, he couldn't say kids can't drink Pepsi anymore, even though that might be great for the public health, unless
we had evidence that, oh my gosh, COVID-19 is directly transferred through soda products. So there is limits there. I also wanted to just mention quickly then the case the Supreme Court decided in 1986, the Yukon case. It was University of Connecticut chapter AAUP versus governor. And it's a different statute, Your Honor, and it discussed about the difference between allotments and appropriations. And it was a delegation and separation of power challenge. But what I just wanted to note in there is the language in that case that they used to delegate authority to the governor to change allotments. The standard was, quote, change in circumstances or, quote, deems necessary. And this court in that case at least said that those standards, quote, are constitutionally sufficient under our law in that they are as definitive as reasonably practical under the circumstances. And I really think that is the test here, Your Honor. And that probably goes to this next part of your question about the intelligible principle. And I'm sorry, I don't know if you asked that. If you did, I apologize. I did. If you say it again.
No, I did ask you to comment on that. So you're on the right track.
Okay. So I think this satisfies the intelligible principle test. Again, Your Honor, there has to be sufficient standards for the governor to apply to carry this statute out. And we've talked about those. So number one, there first has to be a serious disaster. And the plaintiff, again, has conceded that this certainly in magnitude is very serious. You know, I understand maybe they're saying it's not definitionally, but it is very grave. Number two, all the actions the governor can take in B1, he can modify or suspend statutes, but not all statutes. They have to be in conflict with the protection of the public health. And again, specifically related to this pandemic. And I think I already talked about B7, the intelligible principle there. It's only to take actions as reasonably necessary related to this specific pandemic for the protection, safety, health, and welfare of the citizens. And Your Honor, there's been no dispute in this case, I think as Justice Eckert mentioned, that they're not disputing that in this case, closing or limiting the way bars and restaurants operate does not have a public health rationale. I mean, I just saw in the Hartford Courant several days ago a number of doctors saying we need to close restaurants and bars down right now, indoor dining, because of the way it's transmitted. So clearly the actions taken in this case were directly related to the public health, Your Honor.
Thank you.
You may continue, counsel.
Thank you. Justice McDonald, so you sort of how much time I have left. Can you tell me again?
You have 1 minute and 10 seconds.
Thank you, Your Honor. Your Honors, I think given that time, then, unless there's any other further questions, I'll just rest again on my brief. And we believe that certainly this is a very serious time. This is not to be taken lightly. The powers that the governor has, but they are constitutional. They satisfy the delegation principles, and therefore, again, we'd ask this court to uphold the trial court, Your Honor. Thank you very much.
Thank you very much, counsel. Attorney Klein. You muted, sir.
There we go. Just a couple of points I wanted to address. Again, the fact that the courts can check the governor's authority doesn't address the question of whether the legislature has impermissibly delegated its legislative powers to the governor. I also wanted to address the Kentucky Supreme Court case, one of the two cases brought to our attention last night, which was decided in November. A couple of interesting points there that are different from Connecticut. The statute there that the Kentucky Supreme Court was dealing with expanded the scope of disasters and emergencies to specifically include biological and ideological hazards that threaten public safety, which shows how if a legislature wants to include coverage of this type of situation they're dealing with COVID-19, there are a number of ways to do it, and that's a very clear way to do it. The statute there also established a statewide emergency management program in great detail, pursuant to which regulations can be promulgated. And so it set a detailed legislative policy for the governor to implement, which I think the Connecticut statute falls short in. And the court there made the point that the more power that's given to the governor to act in emergencies, because it was given there in that particular state, because the legislature in Kentucky only meets for 30 days in 1 year, 60 days in the alternating year, and the legislature, it pointed out, does not have the power to call itself back into session. So once they're done, and the governor can ignore them. And the Connecticut General Assembly does have the power to convene by action of its own members under Article 3rd of the Constitution and CGS Section 2-6. So another point that in Kentucky, the legislative power can be delegated if the law delegating the authority provides safeguards, procedural and otherwise, which prevent an abuse of discretion, thereby protecting against unnecessary and uncontrolled discretionary power. But in 28-9, there's no protection against unnecessary and uncontrolled discretionary power of the governor. Once he proclaims this is a preparedness emergency, that's he's on his own. The Kentucky Supreme Court so said.
There's a question from Justice McDonald, then Justice Keller.
Thank you, Chief. Counsel, the governor was in issuing his executive orders was just doing what the statutes permit. We have a question about the constitutionality, a very serious one. But it seems like your argument really is that what the legislature did as a body, as an entity, was unconstitutional by giving away its authority. Was the legislature a necessary party to this action? And if so, what do we do since it was not joined as a party in the declaratory judgment, declaring its actions constitutional or unconstitutional?
I don't think I've ever encountered a situation in which the legislature is considered a necessary party to litigation, but in fact,
to be clear, I'm not talking. It wouldn't be a party in every case where a statute is being declared constitutional or unconstitutional. It's the allegation here is that it violated its own personal rights of its branch, and by giving them to another branch of government. So why are they not a necessary party?
It's up to. I don't think they're necessary because it's for an individual such as my client who feels wronged by this to raise the issue, and it can be decided by this court without the participation of the legislature.
That might be true in the normal case, but this is a declaratory judgment action reconciling the jural relations, not really of your client. Your client would effectively be the victim of the problem, but the doubt of the jural relations is between the executive branch and the legislative branch, and we only have one of the branches as a party here.
Well, but if that were the case, the legislature would have been made a necessary party to any challenge about any case involving the non-delegable issue of power. I just don't see that. Here's another question I see.
Yes, Justice Keller.
Thank you. Just a quick question. The legislature, I believe, since March has gone into special session at least twice, and they haven't done anything about these orders. Can we view that as their acquiescence in what the governor's been doing?
I view that as a dereliction of duty on their part, not an acquiescence.
All right, thank you.
You may continue, counsel.
Justice McDonald says my time is up.
I'm giving you time to wrap up if you need it.
I'm just going to make a couple of other points about the Kentucky case, but that's fine. Thank you, Your Honor.
Thank you, counsel. Thank you for everyone involved. I really appreciate your patience on us doing this on this virtual platform. I think it's worked very well this year. We're able to get some things done that we normally couldn't have gotten done. So I appreciate the bar and the judicial employees and the justices and judges who made this happen. So thank you very much. I will for 1 minute see the justices in the virtual conference room. Thank you very much.
Thank you, Your Honor.